Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us, coming to you from Washington's premier indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Hey, America, listen, there is a massive push underway to strip many Americans in several states of their inalienable rights, all by bastardizing a very clear rule of law announced in Heller, reaffirmed in Bruin, but now bastardized by those moving for civilian disarmament. What I'm talking about is taking the in common use test and turning it into in common use for self-defense, because that then allows government to get to decide what's appropriate for self-defense and therefore gives them unfettered discretion to ban whatever the heck they want. We're going to show you today how this disingenuous approach, when you take it to the extreme level by a political advocacy group, can absolutely come up with some of the most offensive arguments. But trust me, these are going to work in some jurisdictions. So today, let's spend a few minutes and let's talk about the lies Giffords will tell to disarm you. Okay, America, we are talking about an assault weapon ban case today. It is one of many cases to come out of the state of Illinois. This one is pending an en banc review before the 7th Circuit Court of Appeals. And of course, I'm talking about Barnett v. Raoul. What we're going to focus on today is an amicus brief filed by the folks over at Giffords, who clearly want to point out that the rule of law, as they see it, even though no Supreme Court sees it this way, is we only protect firearms which are in common use for self-defense. And then because Giffords can prove to us that these firearms are not necessary and totally inappropriate for self-defense, that means the state of Illinois gets to flat out ban them. As a matter of fact, Giffords believes that this is a very straightforward question. We don't even need to do a historical analysis to determine the constitutionality of these bans. This court, however, need not perform this historical analysis because plaintiff's challenge fails threshold first step. The weapons and weapon accessories governed by the challenge laws are not covered by the plain text of the Second Amendment because they are uniquely dangerous and not quintessential or even suitable self-defense weapons. They are weapons of war designed to kill large numbers of people quickly and therefore drastically more lethal than firearms of the 1700s or 1800s. Okay, so you can see already their creative energy going, their imagination is flowing, okay? These things are uniquely dangerous or not quintessential to self-defense. And that's the problem, because if we adopt the rule of law that it's all about in common use for self-defense, all of these arguments, they're going to start popping up everywhere. But ultimately, the big lies that Giffords wants to say is that, listen, anything that makes a shooter more proficient with a firearm, anything that makes a person safer with a firearm and allows them to accomplish their task with greater ease, yeah, that actually makes a firearm less appropriate for self-defense. I'm not making it up. This is how they do it. Assault weapons are not weapons for lawful self-defense. They are weapons of war. And the features regulated by the challenge laws, such as pistol grips, forward grips, and detachable magazines, are designed to increase lethality and allow shooters to inflict severe damage over great distances. Weapons with these features are thus far outside the scope of arms presumptively protected by the Second Amendment. Which means, theoretically, could government then ban arms in the military, including all types of arms, because those clearly are not going to be protected by the Second Amendment? It's food for thought. Giffords then goes on this way, though. Pistol grips attach just behind the trigger and enable the shooter to place his shooting hand beneath the gun. Modern pistol grips were modeled after the Nazi Sturmgewehr to give the shooter another crutch to steady the gun during rapid, prolonged firings. That's right. They are actually claiming that these firearms were designed, who originally by? That's right, the Nazis. But hey, they're not going to stop there. They got more. Pistol grips also enable a shooter to fire from the hip rather than the shoulder. Yes, they really argued that. They are literally arguing things straight from like Hollywood movies now. This is inherently less accurate and thus utterly useless for lawful purposes such as hunting or self-defense, but allows a shooter to indiscriminately spray fire into a crowd. Pistol grips are designed to make such spray firing from the hip particularly easy. Now, you notice how they mentioned that these firearms are not used for hunting or self-defense, and I don't even know why Giffords bothers to include hunting, because theoretically any firearm that's appropriate for hunting as they see fit would not be protected either. Oh, and then forward grips. You know, we got to talk about the forward grips too, right? So what does Gifford have to say about that? Forward grips can be held by the shooter's non-trigger hand, enabling them to exert leverage on the gun with both hands, reducing recoil and maintaining greater control during rapid, prolonged firing. Further, when shooting a semi-auto rifle in rapid fire mode, an enormous amount of heat is generated by the barrel. Thus, by holding the forward grip rather than the hot barrel, the shooter can sustain rapid fire for longer continuous periods. A barrel shroud offers similar protection in prolonged firing. And then, of course, and Giffords really goes as much to say that detachable magazines as a whole should be banned here. Why? Well, because they're scary and they make firearms lethal. Or as they put it, detachable magazines equip firearms with significantly higher ammunition capacity because the number of rounds a detachable magazine can hold is not limited by the size of the gun. They can hold as many as 100 rounds before having to reload and allow shooters to replace an empty magazine with a preloaded full magazine in a few seconds. They are especially lethal when used in combination with features that allow for enhanced control while firing multiple rounds. Now, I know that many of you probably just read all of those quotes and said, that is just a completely ridiculous argument. And you know what? You're absolutely right. But what you need to understand is that if we have courts of law out there that actually believe that the Second Amendment only protects those arms which are in common use for self-defense, and then they have the discretion to determine what's appropriate for self-defense, these are the exact kind of arguments that we're going to be fighting in court moving forward. Okay, the case once again is Barnett v. Raoul. We'll link up the amicus brief down below so that you can geek out on it for yourself. Now, you guys know the drill whenever you're going to read something infuriating like that, right? 3 fingers of bourbon, breathing exercises, or a barf bag. You'll need one of them. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, cool. Click on that link right there and tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, America, let's remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.